Hey guys, welcome back. Today we're going to talk about one of the most important, if not the most important, Supreme Court case in American history, and that is Marberry v. Madison. But before we get to the court case itself, I want to make sure that you understand some terms that are going to be used a lot in this video. The first is the midnight appointments. The midnight appointments were a series of 42 judicial commissions that were created by John Adams during his last few hours in office. Okay. Then we've got a writ of mandamus. This is a Latin term, and it literally means we command, okay, like mandatory command. You're forced to do something. So a writ of mandamus is a legal order forcing someone to do something. And then we've got the Judiciary Act of 1789. This was a law passed by Congress and signed by the president that did a whole bunch of things, but the part we want to focus on for this video is that it gave the Supreme Court the authority to issue a writ of mandamus, and then also judicial review, which is the authority of the court system to determine the constitutionality of acts of Congress or the president. So I'm going to go ahead and share this with you guys through Classroom, but make sure as you're watching the video that you refer back to this if you need a refresher on what these terms mean. All right, so now we're going to go over to the PowerPoint itself. So Marberry v. Madison. This is a Supreme Court case that established judicial review. You need to take that information and file it in the back of your brain somewhere so you remember it, because this is most likely going to be on your EOC. Marberry v. Madison, it established judicial review. It's really important. So we've got a whole bunch of different people that are involved in this case, and some of them play different roles, multiple roles. So I want you to pay attention, pause me whenever you need to jot some of this stuff down on your notes. So here we go. Marberry v. Madison. John Marshall. He starts off in the beginning of this case, or the story, as the Secretary of State for John Adams. And we know John Adams was the second president. John Marshall and John Adams were both from the Federalist Party. Okay, so if you can think back to what you remember about the Federalists and Anti-Federalists, the Federalists wanted a really strong central government, and they believed in the ratification of the Constitution as it existed in 1787. Thomas Jefferson, we know, is the third president of the United States. He was from the opposite political party, the Anti-Federalists. During this time, they were also called the Democratic Republicans. So just know that he was from a different political party than Adams and Marshall. Next, we have James Madison. James Madison obviously plays a role in this, hence the name of the case, Marberry v. Madison. James Madison served as the Secretary of State for Thomas Jefferson. Okay. John Adams, we know, is the second president of the United States. He is responsible for the midnight appointments, which we just referenced on that handout. And then you've got William Marberry. William Marberry was promised a commission, and a commission is another way to say a contract or a job. So he was promised a job by John Adams as a justice of the peace for the District of Columbia, so for Washington, D.C. Now, it's kind of, justice of the peace is kind of a lower federal court position, but it's a federal court position nonetheless. And then the last thing here, the Judiciary Act of 1789, like we talked about on that handout, it did a whole bunch of different things, but mostly it allowed the Supreme Court to issue writs of mandamus, which is a legal order to make someone do something, okay? So the story. Frequently pause and jot down some notes as you go, okay? So John Adams lost his bid for re-election, okay? He lost to Thomas Jefferson. Now, John Adams was a Federalist. Thomas Jefferson was an Anti-Federalist, okay? So one of the things that a president can do is appoint members to the federal court system. That's one of those responsibilities of the president. So before Thomas Jefferson and the Anti-Federalists took office, John Adams created a series of judicial appointments that everyone calls the midnight appointments, because he made these appointments and got them approved by the Senate within the last few hours of his term as president. So we're talking like 9 o'clock the night before his term expires. He is getting these judicial commissions approved, signed, and delivered, hopefully. So John Adams makes 42 midnight appointments. He first has to get the approval of the Senate, which was controlled by the Federalists, before he can send them out. The Senate stays in session until all of the appointments are approved. So then it just comes down to John Marshall signing the commissions and delivering them. Well, he didn't get all of them done before the clock ran out. So there were something like 17 commissions that did not get signed and did not get delivered. So John Marshall, the next day, is no longer Secretary of State. John Adams is no longer president. So the next president, Thomas Jefferson, is in office, and his Secretary of State, James Madison, is in office. Now, John Marshall at this time, this is where it gets kind of tricky. John Marshall was appointed to be the Supreme Court Chief Justice by John Adams. So he was one of those midnight appointments, okay? His appointment, obviously, and commission were obviously delivered. So the next day, he becomes Supreme Court Chief Justice, okay? John Adams is just a normal citizen. So James Madison, as the Secretary of State, it was assumed that he would just go ahead and deliver those 17 contracts that weren't sent out. Well, Thomas Jefferson tells James Madison that he can't do that because Thomas Jefferson is an anti-Federalist and he didn't want Federalist judges to be in the federal court system. So he says, no, James Madison, you can't send out those commissions. Now, if the President of the United States tells you to do something or not to do something, you're going to listen. So James Madison did not send out the commissions. Well, William Marberry, this poor guy who's stuck in this political battle, he just wants his job, the job that he was promised. So he petitions for a writ of mandamus. He asks the Supreme Court for a writ of mandamus, which would require James Madison to send out his commission. Now, there's a couple of different things that John Marshall can do at this time, okay? As Supreme Court Chief Justice, he knows that the Judiciary Act of 1789 granted the court authority to issue these writs of mandamus, okay? So he could have said, okay, William Marberry, you're right. I'm going to tell James Madison that he has to deliver the commission. But John Marshall didn't do that because he didn't know, number one, if James Madison would actually listen to him. So that was one option he had. Another option that Marshall had was that he could have said, sorry, William Marberry, you're out of luck. But he didn't do that either, okay? He didn't want to make the Supreme Court look weak. And I'll talk about how that could have happened in class. So John Marshall, in a landmark decision for the first time ever, he, as a Supreme Court Chief Justice, looks at a law that was passed by Congress, the Judiciary Act of 1789, and he says it's unconstitutional because he believed that that part in the law that gave the Supreme Court the authority to issue writs of mandamus, he thought it gave the Supreme Court too much power. So he looked at this law. He said that is unconstitutional because it gives the Supreme Court too much power. In doing that, he creates and establishes judicial review, which is that authority that the federal courts have to determine the constitutionality of acts of Congress or the president. And no one really wins or loses. Well, I guess William Marberry loses because he doesn't get his commission. So John Marshall, in saying that the Judiciary Act of 1789 gave the Supreme Court too much power, he in turn established judicial review, which gives the Supreme Court kind of like a final check on all the other branches. So, judicial review, the power of the courts to determine the constitutionality of acts of Congress or the president, was established by Marberry v. Madison. If you have any questions about this, please ask me in class. Remember to watch this entire video and remember to take notes on your Google Doc. See ya!